Okay, wonderful. So we still have a couple more people filtering in, but I do show 11:02 a.m. Pacific here on my clock. So let's go ahead and get started. Again, my name is Gerald. I'll be part of the support staff here behind the scenes. And before I turn things on over to our host, thank you very much for joining us today for this presentation titled Feast, Famine, or Barely Enough, Negotiating and Renegotiating Restaurant Leases for Tenants in the Age of COVID-19. Before we start in earnest, a few housekeeping items. Again, if you've joined us by the WebEx link in your registration confirmation, you'll notice that a toolbar is now on your screen that allows you to submit chat messages to the presenters and staff. Please use this if you'd like to ask questions or require technical assistance. All attendees are being placed on mute for this session, and we'll be parsing through questions as we receive them. But we will also have a dedicated Q&A segment at the end of the content as well. So please just type in questions as they come to mind. So next, a version of the materials that we share today will be made available upon request, give or take a couple days after the session. If you'd like to request any materials or follow-up, please go ahead and respond to the invites that had been sent leading up to the event today, or to the post-event follow-up emails that will be sent afterwards. And lastly, just as a reminder, this session is being recorded, and we'll have this available to watch on demand. We'll announce its availability once it's ready to all attendees via email. So with that, I'm going to hand things on over to our host, our national practice leader for the restaurants industry here at Moss Adams, Justine Hunter, to get us started. Justine?
Thank you, Gerald. Good morning, everyone. I want to thank you for joining us. We're trying to have these webcasts to help my fellow restaurant people with this COVID, and I know no one's happy with what's going on. So anything that we can do, or any other ideas you have as far as a webcast, we would love to talk to you about them, and we'll get the content for you. Next page. Okay, so I'm only going to say this really quickly. Material presented is, material appearing in this presentation for informational purposes only should not be construed as advice of any kind, including without limitation, legal, accounting, or investment advice. Whew. I think that's all I have to really say. So you can read the rest of it. Next page. I hate that one. Okay, so we decided to bring in Feast, Famine, or Barely Enough. We have with us today Tony Marks and Michael Heaney with Bryan Cave. I always say Bryan Cave. I know there's two more names. And so they will be discussing really what the key items are for the renegotiation and negotiation of leases. Next page. And here are presenters, little pictures, and also their contact information should you have follow-up questions, or if there's anything that you need as far as a copy of the presentation or video, we can get that to you. Next page. Real quickly on Moss Adams, you know, we're a CPA firm. We do tax consulting and audit assurance practice, and we're here in the restaurant industry, and I guess that's it. I really don't want to talk about us anymore. Let's get on to Bryan Cave and the renegotiating of leases. Tony, I'll send it off to you.
Thank you, Justine. Good morning to everyone. Wanted to give you a quick overview of Bryan Cave. We are an international law firm with, give or take, almost 1,500 lawyers and 31 offices across North America and Europe. We have a culture of one firm so that we are not just profit centers in different offices. We all work together as one firm, treating each other and our clients as one client and as our best clients. We are a fully integrated firm so that we use capacity across the firm, and we also have the capabilities pretty much to be full service. We are a middle market firm, just like, but have the capabilities to go up and down market as well. I'm part of our restaurant team, same with Mike. We again work across platforms so that our restaurant team includes people from, M&A with real estate experience, franchise experience, and all other areas, including licensing, joint ventures, restructuring, obviously real estate, what we're talking about today. Real quickly, Mike is a commercial leasing guru, go-to leasing guy, especially for our restaurant clients. He's one of the leaders of our leasing practice, and he has extensive experience, in that area, both on the landlord side and the tenant side. I'm a corporate lawyer, do a lot of work, looking at real estate. Corporate lawyer, I do a lot of work with restaurants and people in the franchise and distribution law space. So that covers, obviously a lot of restaurants, everything from the coffee shop to, fine dining and fast casual. But getting over to the substance of our presentation, Gerald, if you can move a couple of slides forward, I think. There we go. I will turn this over to Mike to go through and start talking about our feast, famine, and everything else.
Thanks, Tony, and thanks, Gerald and Justine. Hi, everybody. Looking forward to chatting with you all today. We thought we'd start with kind of an overview of where we're going on the presentation and what we wanted to chat about. I call this slide kind of, what is a lease? Why does it normally work? How did COVID essentially break it? And what can we do to fix it? So with that, we kind of have a few high levels talking about how a lease normally allocates risk, what COVID threw everything off, why we can't really look to our normal safety nets, and what we need to focus on going forward. So with that, Gerald, if you want to switch to the next slide, we'll dive in. So a lease, just taking a step back, it's a series of promises. It's a series of allocations of risk. It's the kind of thing where, you probably get frustrated with how long a lease is. It's, hundreds of pages sometimes, because you almost think of it like a computer code. It's a bunch of if this, then statements. And over time, there's been a market that's been established for leases. They take time to negotiate, but on a lot of provisions, you kind of know where you're going and you can expect how a particular risk is going to play out. And a good example of that is casualty clauses. You've probably said to your lawyer at some point in time, don't be wasting time on casualty clauses. We know how those play out. We don't want to spend negotiating time, negotiating capital on that. But a casualty is absolutely something that could come up. And there's been a set array of sort of abatement and termination rights that get negotiated for that, and insurance coverages that you can look to if something were to happen. You can have rental loss insurance for a landlord or business interruption insurance for a tenant. You may look to a mutual waiver of subrogation so that you don't have each party suing each other for property damage, for casualty and things like that. And those things have been streamlined over time. If you want to pop to the next slide, Gerald. Well, unfortunately, with COVID, as I'm sure you're all probably aware, you've got a situation where we didn't plan. Really, no parties planned for an interruption this great and this extensive, affecting all buildings. And we looked to, what do we do in that situation in a lease? And a natural starting point for a lot of leases is to look to the force majeure clause, which speaks very directly to causes beyond the party's control. And COVID, if nothing else, is certainly a situation where it's beyond our control right now. Now, unfortunately, from a tenant's perspective, the force majeure clause in a lot of cases is not a lot of help. One of the things that landlords have negotiated over time, savvy landlords anyway, is that there's very likely a statement along the lines that force majeure is not an excuse from the obligation to pay rent. And some of that's dictated by, landlords have to bow to their lenders, for example, need an uninterrupted rental stream. And over time, it got pretty much negotiated that force majeure would not be an excuse to pay rent. Now, certainly don't want me to be dismissive of that issue, and we can talk about it more. Every force majeure clause is very state specific, very document specific. So please do not dismiss your force majeure clause out of hand. But in general, that clause has not really been saving the day for tenants thus far. So then a tenant might say, all right, well, I've got this business interruption insurance. What am I going to do? That's got to cover me. That's supposed to cover what happens when I get an interruption in my business, for lack of better terms. Now, unfortunately, that's another roadblock for tenants. Insurance companies are, in many cases, pretty savvy. They figured out, especially around the 2013 SARS pandemic threat, that if there were to be a worldwide pandemic, they couldn't cover all these claims, and they thought that they would go bankrupt, which is certainly what they are claiming now. So a lot of insurance companies put a clause, something along the lines that their coverage excludes losses from bacteria, viruses, and communicable diseases. Again, do not mean to be dismissive of that issue. Every insurance policy is different. Coverages are different. Insurance coverages will absolutely still be litigated too. But as a generality, so far insurance hasn't really been saving the day either. Next slide, Gerald, please. So, we might think, all right, what do we do about this risk now? Nobody wants to be left holding the bag. Insurance companies, lenders, tenants, landlords, everybody's losing. Where can we go for some sort of protection? You might think, all right, well, the government has huge resources. Hopefully they'll be the ones that create the safety net for us. And to be sure, there's a lot of government efforts to try to improve things, to try to make things better going forward, or at least provide a temporary solution. But definitely no slam dunks. As we know, the government interventions are sometimes unclear. They absolutely vary by state, by city. They can be temporary, and they're constantly changing. But that said, we can talk about a few things that governments are doing. Most common would be a moratorium on evictions, or perhaps more aggressive, some mandatory rent deferral. There's obviously, every state is different, but we can talk a little bit about some of California and New York examples, as there are some fairly large states that might be in play. Next slide, please. So California, you might think, especially if you're a tenant, that might be a state, if any other, that might look out for tenants and put in some laws that would really make a clear path forward. And to be sure, there are some initiatives. For example, Santa Monica, they forced extensions on rent payments, at least for some smaller commercial tenants. It probably captures at least some restaurants, that initiative. And there are various, deferrals on protections on evictions for the short term anyway. But I think what probably struck a lot of people as a possible panacea, at least for reasonably small restaurants, would be California Senate Bill 939. You may be aware of that one, but at first glance, if you're a restaurant tenant, you took a look, you might say, wow, this is going to be perfect. I hope it goes through. That could be a model for all over the country and save the day. Now that Senate bill, as it was originally drafted, would have made mandatory rent deferral, would have given a period for tenants to actually renegotiate their rights. And it actually, if that couldn't be a renegotiation, there would even be some tenant termination rights. These are possibly all things that restaurant tenants are already looking to their landlords for anyway. So to have it codified in law in a huge state like California would have been amazing from a tenant perspective. Now, obviously, that would have a big financial impact in the state of California, and it was not very appealing to a lot of landlords. So perhaps, unsurprisingly, that bill is currently in the suspense file, and it does not look likely to move forward, at least in its current incarnation. So we shall certainly keep up to speed on what's going on there, but it doesn't look like we're about to have an immediate solution from SB 939. Next slide, please. So New York has taken some similar, but also different approaches to what California did. There's been a lot of executive orders, some local laws that have tried to protect tenants, a lot of variations on suspensions of evictions. But the more updated orders have a little bit more wrinkle. A tenant actually has to show financial hardship before they would get that suspension of an eviction. Another interesting local law was a temporary prohibition on enforcement of personal liability provisions, which for smaller tenants, especially if you have a guarantee that's backstopping your restaurant lease, could be a big help in negotiating, at least in the short term. But thematically, something that's consistent for all these New York and California and a lot of other place measures is that the government's not really trying to permanently solve the problem. They're trying to encourage the parties to come to the table to negotiate. The executive order in New York, for example, expressly encourages the parties to figure out payment plans and indicates that this is supposed to be a short-term measure. And the thinking is that courts, if and when these issues get litigated, are not going to be, real eager to solve the problems for the parties either. They're going to want to try to clear out a backlog docket and encourage the parties to come up with their own plans. So those are two very large states, but again, nothing that they pass is a pure solution to the problems presented by COVID for leases right now. You want to flip to the next slide, Joe? So really the question is, what do we do now? They said insurance isn't really solving the problem. Government is, maybe providing a little bit of help to draw things out so the parties can effectively negotiate. But we don't really know what the market is for lease provisions. I don't even know what the impact on rent rates is going to be. So we're gonna have to try to negotiate and figure some things out. If you want to flip to the next slide. I guess we call this one, staying the course with a twist. And what we mean by that is that, as we mentioned before, a lease is all sorts of allocations of risk. And now we've just got a huge risk that nobody thought of before with COVID that has changed the balance on what you want to negotiate. But that said, we wouldn't suggest that people get too clever with what they're doing. The basics that you're trying to negotiate are still the same. You want to make sure that you can have a great location. You want to make sure that you can have a money-making spot. You want to make sure that the rent makes sense. When you're negotiating an amendment or the regular lease, the things that matter most are the predictable items with monetary consequences, things like operating expenses. But that said, we do have to have something to offer to landlords and tenants to try to make a deal that works better for the parties. So we can take a look at things that maybe we would have pushed harder in the past, or maybe didn't care about so much in the past, and their relative weights, they go up and down. There's things like, for example, maybe in the past you didn't care so much about a co-tenancy clause, but now you do if there's a real chance that a major tenant in your development is going to leave. Maybe in the past you cared a ton about an exclusivity clause, but maybe it's something that you'd be willing to let go if you can get a rent forgiveness in the short term. And there's a whole spectrum of everything that you can do beyond that in terms of, maybe for you it makes sense to add more time at the end of the term, add a big payment at the end. And we'll get into more specifics for sure. But again, absolutely, tenants are going to want to exert their leverage. And that may be maybe not paying the rent in the right situation. But above all else, got to read the whole lease and figure out what the ramifications of taking any of those measures may be. For example, maybe you want to stay current on rent so you can get a step down on a security deposit that's coming up in the near term. So everything's got to be a balance, but some things are going to be more important than others. Next slide, please, Joe. So Tony, I've been chatting for a while. Do you want to talk about some of I suppose, Justine, if there's any questions, maybe we could check in.
I am checking. Go ahead and hand off, and I'll check if there's any questions coming in.
Sounds good. So we have, what are the short-term and mid-term measures we can do right now? I mean, I think we're seeing a number of chains published, household brands that are just sent their landlords letters saying they're not going to pay rent, period. It could be some of the biggest brands like Cheesecake Factory or household names like Gap and Victoria's Secret. That's one avenue, and to use litigation as a possible tool, and we may see that as leverage. And with that, I think there still has to be a plan to go to your landlord, because that's part of the package, I think, that goes along from there. Is developing that package to take to the landlord to show what the economics are. They're going to want to know, did you get a PPP loan? Have you used it? What money do you have left? So on and so forth. What are as you've reopened, what has changed? What has worked or not worked? Were you able to pivot some and go into delivery? And what does the margin look like? What do the numbers look like there? Then there's continuing on, is what's the plan to go forward? And can't, as Mike indicated, are there places that could be used in the lease to adjust? For example, sharing risk with maybe reducing rent, increasing percentage rent, so that there is a sharing of the risk or sharing of success with the landlord. And then there's also looking at what happens and planning for the future if there's a second wave, a further spike, as we are seeing right now, whatever it may be, another pandemic, as leases are long-term relationships. So I think those are some of the quick measures to take a look at in order to stay in the property. What we're hearing also from a lot of landlords is that they're really not interested. Some are not interested. Some of the big ones are not interested in having substantive discussions about renegotiation until they're feeling very confident, or the tenant is coming out saying, look, we're on the verge of bankruptcy, we're going to file, let's negotiate and try to help get around that. So there has to be a push from the tenant's perspective of the landlord to see that there is a possible break in the relationship coming up. So I think we can move on to the.
So Tony, I do have a couple questions. They're going
Sounds
back
good.
just a little bit, and Michael, if this is probably for you. So one question on the insurance coverage: are the tenants having any success on the suits that are being filed, and what is the status of those?
Yeah, I think so far they're very much evolving. I think where there may have been some limited success, there's probably policies that didn't have some of those exclusions for communicable diseases. But I think that those suits are still very much playing out. I think it's definitely a work in progress would be my thoughts so far. Tony, is that sort of what you've been seeing?
That is, I mean, I think that's definitely where things are going.
Okay, and then another question, you're talking about government substitute or assistance and support, and a lot of restaurants have been contacted by the landlord saying, well, you got PPP funds, now you have to pay. I mean, what do you say to that? And have any of your restaurants been successful in kind of negotiating that down, or what's going on with that?
Well, and Mike will chime in as well. I think there's no panacea, and everyone's got to share. There's only so much water in the trough for everyone to take from. When it comes to the PPP loan coming into a restaurant, most did not get 100% of what they were asking for. I actually read an article this morning that for anyone who is still needing PPP funds that's on the line, there's still $160 billion that is waiting to be allocated. But beyond that, so there has to be that financial plan. What does the business look like? What are the needs? And the PPP has specific uses, including the rent, obviously, but also for getting wages going. But also you may not be able to use it for other purposes. So there are other financial constraints on the restaurant. So I think it's still come to the table with a plan, come to the table with information for the landlord so that everyone can see what the financial picture of the business looks like.
So one other question, not that we hate our landlords, but what types of negotiations or settlements have you guys seen? Are the landlords being flexible? Is it more of talk to me when you're about to hit bankruptcy, or are some of them working with the restaurant companies?
Do you want to take that first, Tony, and I'll add my thoughts?
Sure. So I've seen a little bit of everything. I've seen some landlords actually come to the table and say to the restaurant, look, just because they don't pay rent. That's the rare occasion, but I've seen that happen, and that's been in business in buildings that are multi-use where they really need that restaurant to survive in that space because there's other reasons to have that restaurant there. I've seen other landlords, some small landlords, not respond to letters at all, or any communications from the restaurant client or restaurant tenant, and seen those also engage. And then, like I said earlier, some of the national landlords are holding firm, and because they've got pressure from their lenders to collect, and I think they're waiting and playing a little bit of a game of chicken. Mike, what else are you seeing?
I absolutely agree. What I haven't seen is a lot of definitive amendments and negotiations completed yet. I think that there's a lot of landlords that are taking a wait and see approach. Have seen some trickling in amendments getting done, some offers and letters from landlords for rent deferral packages at the moment. But have also recently, as Tony said, been seeing more national landlords saying, no way, nothing, and maybe starting to gear up for some litigation at this point. But yeah, it is definitely some of the smaller landlords have been more willing to work so far.
Okay. All right. Well, one other thing, I just read or was watching the news, and they were talking about evictions and how there's no evictions right now. There's a moratorium on that. Some people fear that once the moratorium's over, everyone's just going to evict. And what do you guys think is going to go on?
Well, I don't think that everyone's going to evict. I do think maybe some of the more national landlords will. I think it's going to depend a lot on the particular tenant and what value they add to the project, and frankly, how likely it is that the landlord thinks that they can get somebody else in there. I have still been seeing, I think some landlords will be more amenable to work with tenants if they think a particular restaurant is an asset to the development. And if they think it's just going to take longer to get somebody else in there, and maybe work with the folks that they know to get someone up and running when they can. But when the moratoriums do run out, I do think that there's going to be an acceleration of litigation for sure.
Okay. All right, I'll let you get back to your slides.
Sure. I think maybe we're popping on to the next one, Joe. Yeah, we did just want to chat about some specifics you might want to consider adding to a project, to a package when you offer it to the landlord. And really the thought being, what's going to make your lease work going forward. Touched on co-tenancy requirements before. Just something to very much think about. It may be that right now your restaurant is smaller and can survive, but maybe it won't if a big tenant goes away. So, and that's more likely than ever. So, co-tenancy definitely something to consider. Early termination options. So there's a clear cutoff at some point in time, and at least you can predict and know what the termination fee might be. And then sort of a bundle of things that you might want to consider in terms of what's going to make carryout and curbside pickup and all that sort of thing, if not work, be more profitable than it otherwise would be. Things like heightened outdoor seating rights. That is another measure where governments are maybe being looser with their outdoor seating requirements. Maybe it's easier to license it up than before, or maybe even some governments are closing streets. So it'd be nice to get some agreement that the landlord would work with the tenant on trying to utilize those rights. And, obviously exceptions to operating covenants. It's always a good thing to have in an operating covenant clarifying, when you're not in breach of that kind of covenant, but definitely something to review and indicate, look, we're not in default if we have another government directive for a waive closing us down for a while. And then absolutely as part of the package, what kind of rent structure is going to work going forward. It's real easy to make a wish list as a tenant, and it'd be nice to be able to flip to a participation rent schedule during some sort of shutdown that you can identify. Again, the landlords aren't going to love any of these things, so it's a package and it's a discussion, and kind of a pitch to them as to what's going to be better for them to get some rental stream. What's the opportunity cost for them to have an empty space for a while, all that sort of thing. I think Tony was going to probably chat about a few other particulars on the next slide. Oh no, I think this one's me too. So yeah, it's continuing on with a tenant dream list. It would be great to be able to get an abatement right if there was a future shutdown. Great to be able to get a termination remedy. Again, landlords are not going to look real favorably on these things, nor are their lenders. But it is part of the conversation anyway. The landlords would definitely want to be detailed on what the particulars are there. Maybe there's some room to get a landlord to try to fund some specific improvements. Even getting down in the nitty gritty of how is UV disinfectant going to work. What HVAC filters might you have? What other improvements can they put in place? Touchless fixtures, touchless doors, that kind of thing. But also very definitely worthwhile talking to a landlord. They're going to want to know what a tenant's going to do in response to future pandemic restrictions. But the tenant would want to know what the landlord's plan is too. What are they going to do if they're faced with a shutdown? So these are all a few more things you want to keep in your toolkit and your checklist when you chat with the landlords.
So Michael, I have another question that came up on that. What about the second wave, which, I don't know, California's starting to, step back on their opening up the state. So, what's going to happen with this increase in cases and the second wave that's, occurring or about to occur as far as negotiating with landlords?
That's a very good question, and I think that's a big part of why you're seeing a lot of landlords take wait and see positions. I think a lot of folks were hoping that with the reopening, they could point to a date or point in time when rental streams would be, if not what they were, or restaurant income streams what they were, but at least closer. And I think there's a lot of nervousness about the second wave that's slowing down negotiations. So that is definitely a wrinkle that's causing trouble. From a tenant perspective, again, I think it's going to be realistic that there are probably going to be waves. I think that the United States is a huge place. There may be shutdowns in one city and not another, which is why the lease, to the extent we can get it, we want to try to negotiate for some flexibility, participation rent structures in the meantime, maybe just for a period while there's a government directive, and other protections along those lines. Landlords aren't going to like to hear it. Their lenders certainly aren't going to like to hear it, but it is something that folks are going to have to be realistic about when they talk about modifying the leases or entering into new ones. Tony, is that any additional thoughts on that one?
I think that's right. I think that there is a hesitance on somewhat on both sides. We're looking for short-term measures right now, what can keep everyone in business, and then without knowledge what's going on, what's going to happen in the future, or then start to look at longer-term plans for how we adapt to a modified normal with whatever mitigation measures are going to be put in place.
So, a question for you: can you describe some of the short-term band-aids that have been implemented? I've seen a couple of my clients just delay payments completely. Their landlords have been okay with it, but what other short-term band-aids are there for the next few months before really renegotiating those leases?
I've seen some look at extending terms of putting in the balloon payments for later, sort of deferring the rent, paying partial rent now, deferring that until later, not just for 6 months after the reopening or the end of the emergency declaration, whatever that might be, but something a little bit longer that really works financially. It doesn't just forestall the financial pressure for a later point. But again, sitting down with a business plan, with financials, and looking at the outlook and trying to work as business partners rather than a landlord, necessarily a landlord-tenant relationship. Mike, I'm not sure what else you're saying.
I think that's right. The most common thing I've actually seen done so far is deferral of rent. For the most I've really seen it deferred is 3 months right now. I've seen some varieties of that being added to the end of the term. Some occasionally, very occasionally, seen outright forgiveness of a month or two, but for the most part, seen rent deferral. I have not seen finalized many fundamental changes to the rent structure or fundamental changes to the deal structure yet, as I think people are kind of playing the waiting game still.
Okay. Another question came in on and I'm going to say this wrong, the HITS restaurant group and the court ruling. Can you give us a kind of a everyday plain English version of what's going on there and what the status is?
Sure, happy to, and that's a good question. The HITS decision, it's an encouraging one for tenants. It's nice to see some good news for now. And that was a decision that a federal bankruptcy court made, where they interpreted a force majeure clause in the tenant's favor. But before I get too eager about it, there's some interesting quirks in the HITS decision that maybe limit just how beneficial it is. For one thing, any force majeure clause is very, very language specific. It's very, very jurisdiction specific. And in this case, it was interpreted by a bankruptcy court rather than a state court. And well, frankly, bankruptcy courts are known to kind of do their own thing sometimes. And it was interesting. Here, the force majeure clause, it did not have what a lot of savvy landlord clauses will have, where a landlord might say force majeure is not an excuse to pay rent. What it said was that lack of money is not an excuse for tenant obligations. And the bankruptcy court judge here, he kind of looked at the document, he looked at, it seems to be he looked at what he thought was fair and kind of worked around the document and the available law to make a result that he thought was fair. In that case, the tenant could do some curbside pickup. The parties didn't actually give him a lot of guidance, but the judge seemed to think that, well, that's roughly 25% what the tenant was making before. So I want to reduce rent by 75%. How am I going to get to that decision? It wasn't a ton of money compared to some leases. So I don't know how hard the landlord will fight the decision. But if you were a landlord's attorney, there's a lot of holes you could poke in that decision. Drafting wise, there were other problems with the language. There's something called the independent covenant to pay rent that you'll have in a lot of leases. That the lease net decision did not appear to have that language. It's pretty important in Illinois anyway, if the tenant's still going to be obligated to pay rent, no matter what, even in a force majeure clause. And a lot of leases will have that independent covenant. And beyond that, the judge didn't really seem to mention the fact that, well, the judge in that case, he very much focused on the governmental directives that caused a shutdown of the restaurant lease. He said that was the proximate cause of why the tenant was unable to pay rent. He did not so much look at the fact that the shutdown order in question expressly said that it didn't excuse the obligation to pay rent. So, there are a lot of holes in that decision, but it's nice to have in a tenant's pocket to think about negotiation. To my mind, if nothing else, it shows landlords that litigation is unpredictable. And sometimes courts are going to try to get to what they think is a fair decision. And if you're a landlord, if you're going to start resorting to the expenses of litigation, it's kind of risky to do that if you're going to get an unpredictable result. So to me, it's maybe one more item to encourage a landlord to try to negotiate something that at least they know what they're getting into in advance, rather than waiting on what a court decides.
So let me turn this on you. What are the risks to the tenant if the landlord has to file for bankruptcy because of unpaid rents?
Now that is a good question. Obviously, if a landlord's filing for bankruptcy, you could have a lender foreclosing, which then you might hopefully have a non-disturbance agreement in place. But beyond that, when a landlord doesn't have funds, the landlord starts not performing its obligations. Things don't get maintained. Tenant allowances don't get funded. You don't get as much of a full building because other people are worried about going in there. So these are all problems for sure. You, as a tenant, you generally don't want your landlord going bankrupt. It is a hazard.
Great, thank you. That's all I have for now.
Great. Gerald, then we'll pick up where we are. If you maybe want to flip a slide over.
So this one I think is mine, and here we've been talking a little bit about defense. How do we deal with the right now and the immediate effects of the pandemic? But I think this is also given in the last several months we've seen restaurants and chains adapt, and with that, what else? Where do we go from here outside of the four corners of the lease, and how do we then work within the lease to take our pivots, our adaptations to our business model forward? So first opportunity, and I'm going to call these, I think these are opportunities, is that restaurants may see opportunity to look at management agreements, and that in that frame, it is either with their existing landlord saying, look, we're going to give up the premises, or give up our right to occupy the premises, but let's switch it around. We'll still operate the restaurant, and we'll take a fee, but really the benefit is for you. So you get to have an occupied space to help with your other tenants and to help bring people to to the building, to the property, but we're not taking the financial risk anymore of continuing to operate a full service restaurant. And this management agreement idea can extend further beyond, a restaurant or a group that has opportunity and has built a model that is seeming to work can look for vacant space and say, I'm not going to come in and lease this space, but I'll come in and run a restaurant in this space. And that leads to with the third point we'll get to in a second, but then also now looking at number two, saying, okay, I'm still going to stay in as a tenant, but I need more flexibility in the space. Instead of needing 5,000 square feet, I've seen really I can operate maybe a smaller dining room with a lot of delivery and to go out of 2,000 square feet. So I want the ability to divide up the space, maybe not the kitchen, but divide up the space into two separate facilities that all operate under separate brands, so I can try to operate and bring more people to the property, to my premises, to the pad that I have, whatever it may be. So that may require consent and working with the landlord in terms of the exclusive use clauses or the use restrictions, the operations covenants, modifications to the building and to the premises and so forth, and maybe even some joint participation in terms of the improvements that are going to happen along with that. And that also dovetails into what Mike was talking about earlier in terms of modifications of the premises, maybe figuring out if you're in a warm weather climate, being able to have more ventilation, meaning sliding doors that open. Maybe there are screens that are there to really create a more open air environment so customers are feeling comfortable. Part of what we're all facing here is our level of comfort, not knowing what the scientific risks are. So you're seeing a lot of people move to the outdoor dining. That also goes to, okay, how do I modify the layout of my premises to facilitate outdoor dining? I can't have servers walking through the front door bringing food. So I've got to figure out how to modify that so I can serve those customers out there. Can I expand? Then can I expand into the parking spaces on a temporary basis? And that will dovetail into, obviously, the ABC rules or your alcohol rules for where you can serve, assuming that you're going to serve alcohol.
So I have a question on that, Tony.
Sure.
I've seen, Manhattan Beach has gotten permission to do that. I know San Francisco is doing the same, and a lot of towns are doing that. Are the landlords asking for more rent because of that, or they're just hopeful that this will help the restaurants pay the rent they do have?
I think it's on the hopeful side right now.
Okay.
I think that you're seeing, we're all in it together, so to speak, and so any opportunity to get business going and to preserve a tenant and hopefully help them pay, it's going to be better. I mean, I think that's generally my view, is that an occupied space is probably better than an unoccupied space, even with most considerations there. So if the city is closing the street in front and they're moving all the tables outside, you can get a number of people to come and dine and actually make some money. That's going to be helpful to the landlord. And I think the landlords that would try to grab more rent out of that would probably not fare well in the press either.
I think. So one more question came up. Do you know of any restaurant operators that have gotten the landlord to agree to a % of the prior year sales instead of a minimum rent, maybe doing, or 50% of rent payments, or 50% of sales, from the prior year? Because we really don't know what the current year sales are going to be. And so would that work with landlords? What do you think?
I'm not sure. I haven't seen. Maybe Mike, you can see if you've seen some sort of interim amendments, but I haven't seen that. But I think that even that might be a difficult target to hit. I think there's going to have to be some multiple levels of flexibility there.
So probably still a minimum rent due, and then maybe some sort of percentage rent after that.
That's where my head would be at right now, is some sort of minimum with a percentage, and maybe at the end of the emergency order that it reverts back, or some other modified arrangement depending upon the level of capacity that's allowed in the dining room at any one time.
So do you think that have negotiations really not happened because people are waiting for a more sustainable volume in the restaurants and more capacity, or what are the landlords thinking?
Mike, you got this, or
Sure.
I wasn't sure.
I think negotiations, I wouldn't say they have not happened. I would say that they're happening. Right now, I think there's absolute dialogue going on. And in some cases, a lot of progress made. I think there's been very few very few instances where folks have reached definitive agreement outside of short-term deferrals, and I think that's because there's just still so much uncertainty.
Okay.
So jumping back here for a second in terms of the what are the sea changes that can happen? I think they're again taking from the learnings. What are restaurants that look at do they have time limitations on when they can serve? So expanding the use of the times of use, and making sure that if they're in a mall or in another location, that services are being offered if they're going to add a day part. If they're a lunch dinner, now they're going to add breakfast or start using the premises to actually serve or deliver. What do they need to do to facilitate that with their landlords? Same thing with changing and dining in times in terms of how late you need to be open. We're seeing even in the shutdown, that really delivery and it was a short window from 4 to 8, 4 to 9 sometimes, and really being open later wasn't helping. And we continue to get to more interesting opportunities. Can you add a co-brand? That goes back to the idea of, do we change the premises to add another brand? Do we look at our kitchen capacity and say, look, we can add a delivery only brand out of this operation? There's going to be no out of this facility, there's going to be no signage here, but we probably need permission under the lease to start operating sort of a second business, so to speak, or brand out of here, because now we're going to have delivery drivers and a higher frequency of them hopefully coming through. So can we do the delivery only takeout brand? It gives, obviously, restaurateurs are seeing that with the rise of the ghost kitchen and using your own facility as a ghost kitchen. Do you need to work with the landlord to facilitate changes to the premises, parking, other areas, to facilitate delivery and takeout, reserve parking spaces for delivery only drivers and so forth? And do they need to have changes to the premises that we talked about to facilitate more outdoor dining? Are you close enough to the parking area where maybe there can be outdoor dining, or maybe there could be some modification? It really is going to take everyone to put on their creativity caps and to see how, if you can have a cooperative landlord and a cooperative restaurant, how to work that out together to make everyone succeed. We can flip to the next page. Mike, I think this goes back to you.
Yeah, and I think this is kind of a wrap up. I know we're almost short of time, but I know, Tony, you had some good thoughts on franchise and licensor considerations. Joe, do you want to flip to that one real quick, and we can make sure we get Tony's thoughts on those items?
Sure. It looks like we lost a few words here, but really, somewhere they disappeared. But here in a franchise licensing or authorized distributor situation, I think the number one step is working with your licensees, your franchisees, to help them develop a plan. Not do it for them, but to be able to have a plan in place that they can take to their landlord, to have that their new business plan. What's the franchisor working on? What's the franchisor implementing? Working on helping them to develop and giving them the tools to develop on their own financial model, their own financial metrics to take to the landlord, to have an intelligent and informed discussion with the landlord about what the business looks like now and what might the business look like in the future. Then going forward, what kind of temporary actions can you help with your system? Encouraging them either with temporary restructuring of the rent and royalties, so on and so forth. And then looking forward to the future. Again, if you're a multi-brand operator, can you work with your system to allow a delivery only option out of their own kitchen if they're not seeing a sufficient order throughput from their own premises there? What can you do to be flexible, and how do you help them continue on? Because it's licensors, franchisors, you're really making money on the royalty, and if you can get increased royalties or preserve that royalty stream, ultimately you'll be better off.
I do have one question. This is really just a general question. What do you think about the market right now? Do you see base rent generally going down or steady? Is it depending on whether it's a mall or street? Where do you see this going?
I think it's a little bit of a game of chicken right now. I do overall, I think see base rents going down. Just because frankly, some tenants aren't going to make it and demand will go down some. But I don't think there's a real clear path on the percentage impact on those changes right now.
Hey, that's all I have for questions, unless there's anything else. You guys want to kind of wrap up and say your last thoughts?
Sure. And actually, I was just going to touch on the market provisions and rents. I think it's an evolution still. For sure, you're going to want to keep an eye out. The next 6 months are going to be very interesting. That's for sure. A lot, whether through the government and others have left it up a lot to the landlords and tenants. So they're going to drive a lot of those negotiations. Your broker teams and things are going to be great to stay in touch with, and as to what they're seeing too on the numbers. But lenders are going to be folks to watch. Absolutely. How flexible they are with the landlords is going to dictate a lot in terms of what the landlords can be flexible with on the tenants. We're going to keep watching those governmental responses, that's for sure. Don't know, there's going to be more. There absolutely will be, but it's going to still vary a lot state to state. And I wish there was clear, easy answers from the government right now, but everything's different. And one other thing definitely want to keep an eye out for is maybe there'll be some more developments on the insurance side. I wouldn't look to an easy solution, but definitely keep an eye out, talk to your insurance brokers. There may be more products that come along on the insurance side. Tony, any other thoughts from you?
Yeah, well, first I want to thank Justine and her team for putting this on. Thank you very much, and hope we were helpful to all of our participants. And obviously you can reach out to Justine and figure out, how to contact all of us for any other questions. I would add there, I'm a deal lawyer, so I like to see deals done. So I naturally want to get the deal done and avoid the courthouse. But I think that sometimes everyone's going to need to think about, do they start actually threatening litigation or get involved in litigation? It may be as potentially as a negotiation posture, or to get to a point where you can negotiate and then really be evaluative of that process, because it is the sport of kings in some respects. It's an expensive process.
And when you do that, absolutely keep track of everything you've tried to negotiate, your outreach. So I think judges they're gonna keep track to see how hard you tried. Sometimes in reaching their decision. If nothing else, it shows that judges can be unpredictable.
That's
Absolutely.
Great.
Well, very good. Thank you very much again, Justine, Tony, Michael, for all of your expertise here on the call today. Here at the conclusion of the deck, we do have a couple of client alert links from BCLP. Feel free to check that out if you request the deck from our presenters. And again, you can put in a request using the invites, replying to the invites that were sent leading up to today's event, or just by replying to the follow-up emails that will be going out later today. Really quickly to close, I realize we're 1 minute over, but there are a couple of resources over at mossadams.com as well that we'd like to point out to you. We have a COVID-19 implications page with the latest in our analysis of various strategies and insights to help you get through this very difficult time. And this is both industry specific as well as industry agnostic. Again, check it out. Also on mossadams.com, we have an overview of, again, this webcast series we're doing for the restaurants industry. This is the second entry in the series, and we will be having more throughout the next couple of weeks. Feel free to check out those topics, presenters, and links to register when they're available through there. And lastly, we also have a series of articles as well. The 4 most recent are also linked here for the restaurant industry as well. And really quickly, I'm going to end the session here with our presenters' contact information up on the screen. It looks like we were able to get through all of the questions in our queue, but please, if you do have any questions that do come to mind after our time today, feel free to reach out to Tony, Michael, Justine, and we'll be able to follow up with you directly there. And with that, thank you very much for joining in for today's session. And on behalf of Moss Adams, as well as Bryan, Cave, Leighton, Paisner, thank you for your time, and we hope to see you again very soon.
Thank you.
Take care, everyone.